and speak to the former Member of Parliament for Tamale Central, Honorable Inusah Fuseini. Honorable, good evening to you, and thank you so much for your time on 505.
Good evening, how are you?
Very fine, thank you. Yourself?
Well, I'm good.
Great. So this is a ruling coming from the Supreme Court. First, let me find out from you your reaction. Did you see this coming?
Well, no, because this is a very important matter, important national matter of tremendous importance. And so I thought that, if they were filing to restrain the Speaker from executing the ruling, that would have been a notice. But as you know, the decision is just about 24 hours old. And the NPP have filed a process in court, has gotten the court to sit, consider the process, and give a temporary ruling, a temporary measure of a stay of execution. So that's my surprise. I'm surprised at the speed with which the Supreme Court has moved, the alacrity with which they have pronounced the decision to restrain the Speaker from executing the decision.
I see. That was where I was coming to, because many are surprised how swift the Supreme Court could work. Again, the instances the Supreme Court made was the law of natural justice. And then again, the Supreme Court says that the Speaker of Parliament should have given these MPs a fair hearing before declaring their seats vacant. Is that something that should have been done?
Well, the Speaker of Parliament acted on the provisions of the law. You say the Article 97 1G does not, either by implication or on the face of it, require the Speaker to give a fair hearing or hearing at all to the members of Parliament who appear to have flouted Article 97 1G. Now, in the same Article 97 1, if a member of Parliament vacates or loses or absents himself from Parliament for a number of days without the Speaker's attention, the provision requires the Speaker to refer the conduct of such a member to a committee. And if he appears before or she appears before the committee and fails to give a reasonable explanation to the committee, the seat of that member of Parliament shall be declared vacant. In that provision, which is part of Article 97, where the framers of the Constitution intended that hearing be given to a member of Parliament who has flouted the provisions of the Constitution, it provides saying, in this particular case, the framers of the Constitution didn't think it necessary to provide for the conduct of such a member of Parliament to be referred to the Privileges Committee.
Council, let us go through the constitutional provision. The Article 97 you indicated. So if you look at the G and H, it says that if he leaves the party of which he was a member at the time of his election to Parliament to join another party, or seeks to remain in Parliament as an independent candidate, or H, if he was elected a member of Parliament as an independent candidate and joins a political party. Are we missing any interpretation here?
You're not missing interpretation. Read 97.2.
97.2. Notwithstanding paragraph G of clause 1 of this article, a measure of parties at the national level sanctioned by the party's constitution or membership of a coalition government of which its original party forms part shall not affect the status of any member of Parliament.
So it means that it's talking about the condition in 97.1G. Is talking about the configuration of the current Parliament. Okay?
Yeah.
So if you are in the current Parliament and there is an agreement between parties to come into coalition with each other, and they so form a coalition based on their constitution or any other arrangement sanctioned by law, that person will be excused from the remit of Article 97(1)(g). You get it? So you must read the provisions together. I hear people arguing the way you have put the question, that Article 97(1)(g) looks to the future, is prospective. But Article 97(2) puts it beyond doubt that it is talking about an existing parliament, not a future parliament.
Now, this is like a battle between the legislature and the judiciary. We've had instances where the judiciary has overturned the ruling of the Speaker of Parliament, where the Speaker of Parliament has said that, look, this is not done in any way. What should be the case going forward? Now, the directive is to allow these MPs do their duties as members of Parliament. What should be the way forward for the Speaker of Parliament and this ruling?
Well, that is why in other jurisdictions, the Supreme Court would not jump into a matter as political as this, because it is a political question that ought to be answered. As the member of Parliament violated Article 97(1)(g), the Speaker says yes. If Article 97(1)(g) is not clear, then it lies within the province of the Supreme Court to interpret it. But where the Speaker has so interpreted it and come to a certain conclusion, it is for the Supreme Court to respect that decision and wait until the case that has been filed before it matures for hearing. Now, what they have done, I don't even know whether the respondents in this case have been served with the petition to for an interpretation of the provisions of the Constitution, that is Article 97(1)(g). I don't know, and it is quite clear that the stay of execution that was granted this morning or afternoon to the petitioners or applicants was without notice to the respondents. So the combined effect is that one group of people have been able to move the Supreme Court by a petition to the Supreme Court for an interpretation and by an application for an interim measure to secure the release that they want. That is to tie the hands of the Speaker from executing his ruling. And I think that the requirements of justice and fair play, if they are talking about natural justice, then why will they fault the Speaker on the basis of refusing or failing to give the applicant the right to be heard, and then refuse the respondent of a right to be held in an important exercise as staying the execution of a ruling of the Speaker.
Now, the question the general public is asking is who is then the majority and the minority, because numerically, after the speaker's declaration of the 4 vacant seats, we have NPP at 135 and NDC as 136. Now, from what the Supreme Court is saying, we do not know the judiciary verdict and the numerical verdict. Who then becomes the majority?
What the Supreme Court is basically saying is that the status quo ante, what prevailed in Parliament before the ruling of the Speaker, must be the norm, the reality. Must be what must be in existence. Basically, the Supreme Court is saying that the 137 MPs of the NPP and the 137 MPs of the NDC must still, and the independent candidate Andrew Asiama must still be
an independent candidate.
The independent member of Parliament, Andrew Asiama, must still be members of Parliament. That is two rogue MPs from NPP, the 1 rogue MP for NDC, and the rogue independent member of parliament must still be members of parliament. That's what the Supreme Court is saying. So a majority, minority, in terms of the ruling of the speaker, doesn't come in at all.
What do you anticipate on the camp of Speaker of Parliament?
Well, they can go to court now on an application or notice to have the stay of execution removed. But my fear is that will unnecessarily embroil the Supreme Court in partisan political activity. They will be seen as more partisan. And I'm lamenting the conduct of the Supreme Court because the fidelity of the law ought to be respected. The Supreme Court has jurisdiction to determine whether a constitutional provision says what it says or it means some other thing. They have exclusive jurisdiction. That is the interpretative jurisdiction of the Supreme Court. It should not be the case that a person takes a decision based on the understanding which decision is not perverse, which decision is consistent with an earlier decision, and the Supreme Court says, well, we have not yet given our decision on the invocation of our jurisdiction to interpret that provision, but we stay your hand, don't execute it. I mean, I think that this is the first time I'm hearing the Supreme Court do that, or seeing the Supreme Court do that. So, I mean, it's just unfortunate. But well, we have to live with it.
Right, Council, thank you so much for your time this evening. That's the former Member of Parliament for Tamale Central, Honorable Inusah Fuseini.